Hi guys! Welcome to another episode of Attorney Vlogger. Today we continue with our discussion on the law of agency. And specifically, we'll be talking about the power and authority of the agent to bind the principal and third persons. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. A like on this video or any of my other videos would be greatly appreciated. Also, as a reminder, there's an ongoing raffle and I highly suggest that you guys join. I'll be giving away 3 days worth of Tierra plant-based meal plan deliveries. Okay, you'll be receiving breakfast, lunch, dinner, and a snack for 3 days absolutely free care of Tierra Meals. Please just watch the video for the rules and just join. Okay, now let's begin with our discussion. So today, as I mentioned, we'll be talking about the power and authority of the agent. It's the role of such power and authority in the relations between the principal and the agent, as well as the relations, rights, and obligations among the principal, agent, and third persons. Our discussion today will involve Articles 1881 to 1883, 1887, 1897 to 1902, and 1916 and 1917. Okay? As I just mentioned, there is a relation created between the principal and the agent on one hand, okay? Goku is the principal, Vegeta is an agent, and they have rights and obligations to each other, which will be the topic of the following videos. But there is also a relationship created between the principal or the agent, as the case may be, with the third person with whom they contract. Okay? That is Broly for today's episode. Okay, so again, there is a relationship between the principal and the agent, and there is a relationship with the principal or the agent, as the case may be, with the third person. Okay? To review, by the contract of agency, a person binds himself to render some service or to do something in representation or on behalf of another with the consent or authority of the latter. The contract of agency establishes a relationship between the principal and agent, in that by giving the agent authority to act on his behalf, the principal is placing his trust and confidence in the agent. And the effect of the grant of authority to the agent is that the agent now has power to perform certain acts on behalf of the principal, which will bind the principal to the third person. And in case an agency exists, the liability of a third person is to the principal and not to the agent in case of the existence of an agency. Okay? And as a general rule. Now, while the words authority and power may often be used interchangeably, they are actually different. Authority of an agent is the mandate given by the principal to the agent in order to affect the legal relations of the principal by performing acts which must be done in accordance with the principal's manifestation of consent to the agent. Power, on the other hand, is the extent of such mandate or the agency itself. So authority is the source or the cause of the power, and power is the effect of such authority. The principal grants authority to the agent, and the agent now has power to act for the principal. Now, there are different kinds of authority of the agent. We have express, which is easy enough to understand, but we also have implied authority, such as when it is incidental to the transaction or reasonably necessary to accomplish the purpose of the agency, such as stated in 1881 that the agent may do such acts as may be conducive to the accomplishment of the purpose of the agency. So for instance, if the authority is to buy, the implied authority is also to pay for the thing which is bought. Okay? Because you cannot buy without the power to pay. Another kind of authority would be the apparent or ostensible authority, which is conferred by the conduct or even by silence of the principal. And this is agency by estoppel, which we already discussed in the previous episode. We also have general authority, so when it refers to all the business of the principal, and we have special authority when it is limited to one or more specific transactions. And we also have authority by necessity, which is when it is demanded by virtue of the existence of an emergency. So by virtue of the agency, the agent has the power to bind the principal, and in order for the principal to be bound to third persons by the act of the agent, there are two requisites. Under 1881, the agent must act within the scope of his authority, and under 1883, the agent must act on behalf of the principal and not in his own name, meaning not in the name of the agent. He has to act on behalf of the principal, in the name of the principal, in representation of the principal. So now let's discuss the first element. In order for the principal to be bound by the agent's acts, the agent must act within the scope of the authority granted by the principal. When we say that the agent must act within the scope of his authority, it is as if the principal has said, "Oh, ito lang pwede mong gawin ha. These are the only things that you can do." And this follows the principle that he who does a thing by an agent is considered as doing it himself. Therefore, the principal is liable for obligations contracted by the agent, but only if the agent acts within the scope of his authority. So the general rule is that the agent must act within the scope of his authority as provided for in 1881. But this general rule is qualified by two other rules. First, the doctrine of implied powers in agency, which is also in 1881, which states that the agent may do such acts as may be conducive to the accomplishment of the purpose of the agency. It is also qualified by the second rule under 1882 this time. The limits of the agent's authority shall not be considered exceeded should it have been performed in a manner more advantageous to the principal than that specified by him. In other words, there is an additional benefit to the principal. Okay? Now, under 1897, as long as the agent acts within the scope of his authority, he will not be personally liable to the party with whom he contracts, the third person. No? And now the principal will be bound by the act performed by the agent. This is because the agent who acts within the scope of his authority is properly representing the principal, with the effect that it is as if the principal himself entered into the contract with the third person with whom the agent contracted. A person who is acting as a mere representative of another acquires no rights whatsoever, nor does he incur any liabilities arising from the contract between his principal and a third party. So the end result is a contract between the principal on the one hand and the third person. Wala na si agent, okay? The agent is a mere tool that the principal used to enter into a contract with the third person. Further, as long as the agent acts within the scope of his authority, the principal cannot get out of the contract with the agent, which the agent contracted, by merely citing the agent's ignorance of certain circumstances. Because under 1899, if a duly authorized agent acts in accordance with the orders of the principal cannot set up the ignorance of the agent as to circumstances whereof he himself was or ought to have been aware. So 1897 presents us with the general rule that the agent who acts as such agent is not personally liable to the third person with whom he contracts. The same article gives us the exceptions, meaning that even if the agent acts within the scope of his authority, he will still be liable if, first, if the agent expressly binds himself, which is easy enough to understand. If the agent explicitly says that, I will also be liable under this contract of my principal, then of course he will also be bound. Second, if the agent exceeds the limits of his authority without giving the third party sufficient notice of his powers. Okay, he did not inform the third person. And one more exception under 1909, in case the agent is guilty of fraud or negligence. So, if the agent acts in the name of the principal and within the scope of his authority, the contract is valid. Okay? It's valid between the principal and the third person. The principal is bound to the contract with the third person and the agent is not personally liable following the rules in 1881 and 1897. So, let's say Goku as principal asks Vegeta to sell his car for 500,000 pesos cash. Okay? Vegeta sells the car on behalf of Goku for 500,000 pesos cash to Broly. So, in that case, no question, contract is valid. Okay? A contract now exists between the principal, Goku, and the third person, Broly. And Broly may now enforce the contract against Goku, and Goku may enforce the contract against Broly, but neither Goku nor Broly have a cause of action against Vegeta because Vegeta acted in Goku's name and within the scope of his authority. Walang kasalanan si Vegeta. Okay? Now, what happens if the principal denies the agency? He says, no, there's no agency. Then the third person or the agent, either of them, they have to prove that the agency exists in order to hold the principal liable. Okay? Otherwise, the third person will just now hold the agent liable. Ultimately, in case of failure to prove the agency, the third person can hold the agent liable. Why is the rule like this? This is to protect first the innocent third person who transacted in good faith. Okay? But it also protects the principal in case there are unscrupulous people pretending to be agents when such is not the fact, no? Let's say Vegeta sells a car to Broly saying it belongs to Goku, but Goku never asked Vegeta to sell that car. So, now, Vegeta will be personally liable because no agency exists at all. So, it protects the third person and protects Goku, the principal. The third person can simply go after the agent in that case, okay? If there is no agency. Now, let's move on. What if the agent acts without authority or exceeds the limits of his authority? It depends. There are two situations. First, if the agent acts without or in excess or beyond the scope of his authority without giving the third person sufficient notice of his powers, hindi niya sinabihan, no? Then such act will be what? Unenforceable against the principal. Meaning, the third person cannot enforce the contract against the principal. Why? Review your oblicon. Okay? Remember the first paragraph of Article 1403 on unenforceable contracts. Okay? Those contracts entered into in the name of another person by one who has been given no authority or legal representation or who has acted beyond his powers. Those are unenforceable contracts. Just take note, of course, of the special rule or the qualification that in case of a sale of land where the authority of agent is not in writing, the contract of sale is void. Okay, that's the special rule. So, who can the third person hold liable? The agent will be personally liable, okay, to the third person under 1897 because he exceeded his authority. However, there are exceptions to this rule, meaning that the principal can still be bound and will therefore be liable. First, if the principal expressly or impliedly ratifies the contract entered into by the agent, even if it is done without or in excess of the authority. Okay, like when the principal says, okay, yung ginawa mo, you did a good job. That's express. Or even if it does not say words, but the principal performs acts adopting the agent's acts, like accepting the benefits of the acts performed by the agent. That is implied ratification. Take note that under 1901, a third person cannot set up the fact that the agent has exceeded his powers if the principal has ratified or has signified his willingness to ratify the agent's acts. Okay? Another exception would be under 1882, which creates a presumption where the agent is not deemed to have exceeded the limits of his authority if the agent performed the acts in a manner more advantageous to the principal than the authority actually granted, in which case the contract will be valid. And one more, under 1911, even when the agent has exceeded his authority, the principal will be solidarily liable with the agent if the principal allowed the agent to act as though he had full powers. So, in the example earlier, if Vegeta sells the car on behalf of Goku to Broly for 500,000 but in 50 installments, okay, not cash. Remember the example earlier said cash. And there is nothing in the facts that says Vegeta gave Broly sufficient notice of his powers. What is the effect of the contract of sale? What's the status? The sale is unenforceable. Okay, Broly cannot enforce the sale against Goku. Why? Because it was done beyond the authority granted to Vegeta. Goku did not say that Vegeta can sell on installments. He said cash. Okay, but Broly can hold Vegeta liable on the contract because Vegeta exceeded his authority under 1897. However, just take note, since the car belongs to Goku, of course, Broly cannot hold Vegeta liable to deliver the car. So the liability of Vegeta is now converted into liability for damages. Unless, of course, Goku ratifies Vegeta's act, in which case, the contract now becomes valid, binding, and enforceable against Goku. In case Goku ratifies the contract, then what if suddenly Broly does not want to push through? Okay? Can Broly say that the contract is unenforceable because Vegeta exceeded his authority? Not anymore. Okay? The contract is now valid because Goku had already ratified it. Remember what I said earlier under 1901. A third person cannot set up the fact that the agent has exceeded his powers if the principal has ratified or has signified his willingness to ratify the agent's acts. Now, what if Vegeta sells the car on behalf of Goku for 600,000 pesos cash? Not installment, cash. Okay? In this case, Vegeta can still be said to have exceeded his authority because the instruction of Goku was to sell for only 500,000. Okay? What's the status of the sale to Broly? Is it also unenforceable because Vegeta exceeded the scope of his authority? No. The sale is valid. Why? Because even if in reality, even if Vegeta exceeded his authority, the law presumes Vegeta to not have exceeded the scope of his authority granted because it was more advantageous to the principal Goku. He earned an extra 100,000. In that case, the contract between Goku and Broly is now valid. And if Vegeta exceeded his authority and Goku allows this, such as in the second example where he sold it on installments despite the instruction being for cash, if Goku allowed that, then Goku and Vegeta will now be solidarily liable under 1911. Okay? So that's the discussion for the first situation where the agent exceeds the scope of his authority without giving the third person sufficient notice of his powers. Now, second situation. If the agent acts without or in excess of the scope of his authority, but he either gave notice of his powers to the third person, or the third person is aware of the limits of the powers granted to the agent and the principal does not ratify the contract. This is found in 1898, which declares such contract between the principal and the third person as void. Okay, that's what the law says. But take note that authors like De Leon and Jurado opine that they hold the opinion that even though the law says that the contract is void, what is really meant is that the contract is unenforceable, since the law declares that the contract is capable of ratification. And remember your oblicon, a void contract can never be ratified. Since the law allows for ratification, it is presumed that what the law really intended was to declare the contract as unenforceable. Okay? So here, even if the agent exceeds the authority granted, he will not be personally liable in two cases. If the agent either gave notice of his powers to the third person, or the third person is aware of the limits of the powers granted by the principal. 1898 then takes this further. If the agent promised to secure the principal's ratification and fails to obtain it, meaning the principal does not ratify the contract, then the agent will now be personally liable under the contract. But of course, if ratification is obtained, Goku says, okay, meaning the principal ratifies the contract, then the contract will now be valid and will now bind the principal. So the rule is that third parties who deal with agents must inquire into the existence of the agency. Is there really an agency? Okay? And they must also inquire into the nature and extent of the authority of the agent. Okay? Did your principal allow you to do this? Are you authorized to sell or just give an offer? Like that. Okay? They must inquire into the existence of the agency and the nature and extent of the authority if these third persons want to hold the principal liable. Okay? As such, 1902 provides that a third person with whom the agent wishes to contract on behalf of the principal may require the presentation of the power of attorney, GPA or SPA, or even the instructions as regards the agency. Okay, Broly can ask Vegeta, hey, show me the SPA. Okay? And they actually have a duty to do that. Okay? Because the rule is that persons dealing with an agent are bound at their peril, if they want to hold the principal liable, to ascertain not only the fact of agency but also the nature and extent of the authority. And in case either of those are disputed, the burden of proof is upon them to establish it. If the third person does not make such an inquiry, then he is now chargeable with knowledge of the agent's authority, and his ignorance of that authority will not be an excuse. So, as far as third persons are concerned, under 1900, an act is deemed to have been performed within the scope of the agent's authority if such act is within the terms of the power of attorney as written. Okay, if it's within the SPA itself, even if the agent has in fact exceeded the limits of his authority. Basta nakasulat, kahit in reality he exceeded, if it's written, then that is okay. Okay? Again, an act is deemed to have been performed within the scope of the agent's authority if such act is within the terms of the power of attorney as written, even if the agent has in fact exceeded the limits of his authority according to an understanding between the principal and the agent. Why? Because under 1902, private or secret orders and instructions of the principal do not prejudice third persons who have relied upon the power of attorney or instructions shown upon them. In other words, as long as you're looking at the written instrument and it says it lists down the acts that the agent can do, private or secret orders will not affect you. Okay? In other words, if the agent presents the written power of attorney to the third person, as far as the third person is concerned, if the act of the agent is within the terms of the power of attorney as written, then it is deemed or presumed to be within the scope of the agent's authority, even if in reality the agent exceeded the limits of such authority according to a secret understanding between the principal and the agent. The third person does not have to ask about the instructions of the principal anymore. He can simply rely on the written power of attorney. Still, the same example earlier of Goku authorizing Vegeta to sell his car for 500,000 pesos cash. So Vegeta now meets up with Broly as the prospective buyer. Assuming that Vegeta discloses to Broly that Goku is his principal, then Broly has the obligation to inquire into the scope of Vegeta's authority by asking for the power of attorney. Okay, unless of course Vegeta offers the information first or right away. Okay, Broly should ask Vegeta, "Oh, show me your SPA." Or Vegeta can go ahead and say, "Sir, here is my SPA. I'm authorized to do this and that, etc." Okay? Now, first scenario. The written power of attorney that Goku gave to Vegeta just says, sell the car for such price and terms as may be reasonable. But Goku and Vegeta have a secret understanding not to sell the car for less than 500,000. If Vegeta sells the car to Broly for 400,000, did Vegeta exceed the scope of his authority? No. Why? Because the instruction of Goku was a private or secret order. As far as Broly is concerned, Vegeta's act is deemed to have been performed within the scope of the authority granted by Goku, since it is within the terms of the power of attorney as it is written. As such, Goku will now be bound to the contract with Broly. Second scenario. Vegeta presents the written power of attorney to Broly, where it is written that Vegeta must sell the car for no lower than 500,000 pesos. Broly now has notice of the limits of the power granted to Vegeta. Let's say the car of Goku is now sold to Broly for 400,000 pesos, which is an act done without or in excess of the authority granted to Vegeta. What is the effect? First, of course, if Goku ratifies the contract, no problem. It is valid and binding on Goku, and Vegeta is not liable to Broly. Second, if Vegeta did not undertake to get Goku's ratification and Goku did not ratify the contract, under the law, the contract is void, but more appropriately, as according to De Leon and Jurado, the contract is unenforceable, following 1898. Now, if Vegeta undertook to secure Goku's ratification but Goku did not ratify, he did not say, "Oh, okay ang ginawa mo," then Vegeta will now be personally liable to Broly. Of course, if there is ratification, then Vegeta will be relieved from liability and Goku will instead be bound. So the general rule is that the principal is bound by the agent's acts if the agent acts within the scope of his authority. Conversely, the principal is not bound by the acts of the agent which are done beyond the limits of his authority. This creates a duty on the part of the third person that they should inquire into the existence of the agency and the extent of the powers of the agent. However, the principal will still be bound by the agent's acts even if the agent exceeded his authority if, first, the principal performs an act which contributes to deceive the third person who has acted in good faith. Second, where the third person could not have known the limits which the principal placed upon the authority given to the agent. Third, if the principal gave the agent blank instruments. Fourth, where the principal has ratified the acts of the agent. In those cases, the principal will still be bound by the agent's acts even if the agent exceeded his authority. So, to summarize, when the agent acts within the scope of his authority, the principal is bound, meaning the agent is not liable and the third person can hold the principal liable. However, the agent will be liable even if he acts within the scope of his authority if he expressly binds himself or he is guilty of fraud or negligence. When the agent acts without or beyond the scope of his authority, the contract with the third person is unenforceable. Just take note of the special rule where the sale of a piece of land is done through an agent and his authority is not in writing, then the contract of sale is void. If the agent acts without or beyond the scope of authority, generally the principal is not bound, except where the principal ratifies the contract, has allowed the agent to act as though he had full powers, or where the agent acted in a manner more advantageous to the principal. And where the agent acts beyond the scope of his authority, the agent becomes liable to the third person, and the third person cannot hold the principal liable, except that if the agent undertook to secure the principal's ratification, the contract will be unenforceable if the principal does not ratify it. If it is ratified, then no problem. There is a contract now between the principal and the third person. So that's the discussion for the first element, that for the principal to be bound to third persons by the act of the agent must act within the scope of his authority. For the second element, the agent must act on behalf of the principal and not in his own name. Remember that the essence of agency is representation, that the agent is performing acts on behalf of the principal. If the agent is acting in his own name, then he's not representing his principal, but he's creating a contract for himself. Therefore, if the agent enters into a contract with a third person in his own name, a contract is created between the agent and the third person, and as such, the third person can hold the agent liable on the contract. But can the third person hold the principal liable and vice versa? 1883 says that if an agent acts in his own name, the principal has no right of action against the third person with whom the agent has contracted, and those third persons have no right of action against the principal. In short, the agent is the one directly liable to the third person as if the transaction were the agent's own transaction. Why? Because there is no representation here. The agent acted for himself, so the principal cannot be bound. The contract created is one between the agent and the third person, and the principal is not part of the contract because the agent was acting in his own name. Remember your oblicon again, the principle of relativity of contracts under 1311. Contracts take effect only between the parties, their assigns, and heirs, except in case where the rights and obligations arising from the contract are not transmissible by their nature, by stipulation, or by provision of law. So to answer the question earlier, the third person cannot hold the principal liable following 1883. 1883, however, provides an exception, and that is where the agent acts in his own name, but the transaction with the third person involves things belonging to the principal. In this case, the principal is bound and the contract is considered as entered into between the principal and the third person for the purpose of protecting innocent third persons against possible collusion between the agent and principal. However, this exception does not apply if the agent has exceeded his authority. Of course, as 1883 says, this is without prejudice to the actions between principal and the agent, meaning the principal still has the right to hold the agent liable for damages for his failure to comply with the agency or any other action in law. So let's say Goku told Vegeta to buy a car. Vegeta went to the dealer, but he did not say he was acting for Goku, and so Vegeta bought a car. The sale will be considered to have been made in Vegeta's own name, and it will not bind Goku because Vegeta acted in his own name. So if the dealer wants to sue Goku for payment, can he? No. Okay? Because Goku was not disclosed to be Vegeta's principal. Walang kinalaman si Goku dun sa kontrata. Okay? So, Goku, however, can still sue Vegeta for damages for failing to comply with the agency to buy a car on his behalf. Okay? Now, what if Goku asks Vegeta to sell a car which Goku owns and Vegeta sells it to Broly? Okay? Saying that the car belongs to Vegeta. Hey Broly, buy this car, it's mine. Okay? Is Goku bound? Yes. Okay? Because the sale involves a thing belonging to the principal, Goku. The implication is if the third person wants to sue for warranties on the car, he can now sue Goku. This example is different from the example earlier where Vegeta sold the car to Broly, where Broly asked for the written power of attorney of Vegeta. In the example earlier, Vegeta was not acting in his own name, but he was acting on behalf of and in representation of Goku. What happened there was that Vegeta acted without or exceeded the scope of his authority. As such, pursuant to 1898, the contract is void or more appropriately, unenforceable. In the current example, Vegeta acted in his own name in selling the car to Broly. And under 1883, since the object belongs to the principal Goku, it falls under the exception to the rule where the agent is bound. Here, by virtue of the exception in 1883, Goku will now be bound to the sale and he will be obligated to deliver the car because the car belongs to Goku. Of course, Goku can still bring an action against Vegeta for damages as may be warranted by the circumstances. And we also have now the doctrine of agency by necessity, which I mentioned in the first or second episode, no? If there is an emergency, the authority of an agent is correspondingly enlarged, okay, in order to cope with the exigencies or the necessities of the moment. For this doctrine to apply, the following are the requisites. First, the real existence of an emergency. Second, the inability of the agent to communicate with the principal. Third, the exercise of the additional authority for the principal's own protection. And fourth, adoption of fairly reasonable means. Take note that an agency can never be created by necessity. What is created is only additional authority on the part of the agent, and he is deemed authorized before right at the point that the emergency arose. So, let's summarize the relations between the principal and the agent. The general rule is that the principal is bound by the agent's acts if the agent acts in the name of his principal, not in his own name, and if he acts within the scope of his authority. Conversely, the principal is not bound by the acts of the agent done beyond the limits of his authority. This creates a duty on the part of a third person. They should inquire into the existence of the agency and the extent of the powers of the agent. Take note of the special case of 1916. When two persons contract with regard to the same thing, one of them with the agent and the other with the principal, and the two contracts are incompatible with each other, that of the prior date shall be preferred without prejudice to the provisions of Article 1544 on double sales. I have a video on double sales. Please just watch that. 1917, on the other hand, provides for the effects of such a situation described in 1916. If the agent acted in good faith, then the principal shall be liable for damages to the third person whose contract must be rejected. If the agent acted in bad faith, then the agent alone will be responsible for damages. And finally, the rule for delicts, crimes, or quasi-delicts, torts of the agent is that as long as the agent acts within the scope of his authority, then the principal is liable for the delict or quasi-delict of the agent. But the agent is liable to the principal not only for fraud, but also for negligence. Okay? So that's the discussion for power and authority of the agent to bind the principal and third persons. I hope you may have picked up a thing or two, and I hope to see you next time, guys. See you soon. Bye.